Welcome, everyone, to the third and final day of the Elder Justice Decision-Making Capacity Symposium. For those of you who were unable to join us yesterday, we focused on two common scenarios that arrive in potentially criminal cases and explored how capacity can play a role in both of those matters. In one case scenario, which involved potential financial exploitation, it appeared that a younger companion had taken advantage of an older gentleman. And the question was whether or not he had the capacity to consent to giving away his money or allowing the younger companion to have spent his money. In the second scenario that we focused on involving neglect, the question was whether a mother had voluntarily and knowingly and was able to consent to forego medical treatment and care, leaving her to live in very horrible conditions. In both of these cases, the key question in terms of whether or not it would be pursued criminally was whether or not the older adult had actually consented to the conduct at issue. And because of that issue, the ancillary issue was whether or not they indeed had the capacity to consent. We chose, as Nina mentioned the very first day, capacity plays many different roles in our legal system. In some circumstances, the question of capacity, an older adult's decision-making capacity could impact whether or not his or her rights in total or in part are taken away, as in a situation that will be discussed in today's panel. In other situations, however, an older adult's capacity and decision-making capacity will impact whether or not justice is served, whether or not an individual's rights are vindicated, and whether or not a criminal investigation or prosecution even makes it out is pursued. As one of our colleagues, Paige Ulry, has noted, the scenarios that we talked about yesterday are ones that are extremely common and are cases that oftentimes die on the vine. They die on the vine because of process failures, because somewhere along the way, someone may not have taken the time to take a closer look, to ask the right question about whether or not the older adult actually had the capacity to consent to what was happening. And so what we did was we put together a stellar multidisciplinary panel to help us look at these two cases through the prism of their work, to better understand what each link in the chain thinks about when they see such a case, and help us better understand where potential gaps or vulnerabilities may be in that process. Naturally, we started the process with APS, and Michelle did a phenomenal job yesterday of walking us through how APS would conduct its evaluation, what it would consider in terms of its interviews, and the circumstances under which APS or Michelle might conduct a preliminary capacity screening to get a sense of the individual and conduct interviews, and when she may make a referral to law enforcement and flag the issue of potential capacity-related issues. I think it's worth spending a moment on this initial handoff between APS and law enforcement. Yesterday, we had the benefit of an all-star panel of individuals who had decades of experience, many of whom had years of dealing with capacity-related issues. So, of course, they know exactly what to do, what questions to ask. That's not always going to be the case. There may be times when there's a very experienced APS worker, but a brand new law enforcement officer, or vice versa. And so I think one theme that came out of yesterday was that it's critical that no matter who is involved in a particular situation, that there be clear communication and collaboration between APS and law enforcement. That means it's incumbent upon APS to be very clear about what they did and what they didn't do, what screening they may have done, and what that can and cannot mean in terms of inferences about an individual's capacity. The fact that APS may do a preliminary screening to determine whether or not the person may be vulnerable is not necessarily and cannot be used as a dispositive determination as to the older adult's decision-making capacity. On the other side, law enforcement cannot make that assumption. I think based upon our experience talking with law enforcement officers around the country, they're not trained on this stuff. There's very little training. They may not understand what these screening tools are, what they can and cannot be used for. And so there's an information gap. And it's very, very easy, I think, for law enforcement to just hear that someone did an assessment, that someone seemed okay, the older adult, seemed to be lucid, and therefore just assume automatically that the person had capacity, financial decision-making capacity. And that will have profound implications on how the police will treat the case, whether or not they'll dig in, what they'll look at. Skip, our police officer representative, made these very points. He talked about the many different facets of an investigation that he pursues, how he will analyze the financial history of the older victim. He will investigate the relationship between the older adult and the alleged defendant, and get a real sense of the relationship between the two, how it evolved, what is happening. But perhaps most critically, Skip emphasized the fact that he does not ever assume that the older adult has capacity, decision-making capacity in that situation, that you have to do the work, you have to dig in, you have to ask the questions, you have to really develop that context to begin to see whether or not there may be a situation where the consent was not valid. And only when that situation arises, he may then make the referral and seek the guidance of a clinician on his MDT team or elsewhere to do a full capacity assessment, to really delve into that if that's necessary. So it's a multi-step process. And again, he doesn't assume anything at the outset. It's really a matter of developing the facts. And again, like with APS, this is perhaps, in my mind at least, perhaps the most critical step of the criminal process, because prosecutors work the cases that they're given. They work the cases that are brought to their attention by law enforcement and by the police. And if law enforcement does not ask those questions, do not take the time to peel back the layers and get a better sense of whether or not there may be a capacity issue here, that the consent may not have been valid, they didn't ask the question and dig in, then they may not present the case to the prosecutor or present it in the right way. And that means the prosecution will never really take off. It'll never be pursued, and it won't see the light of day. So again, the role of both APS and law enforcement is critical in asking the questions in order to frame it so that when the prosecutor first sees it or hears about it, they have the context that they need. Jane, our prosecutor, also did a phenomenal job talking about all the different considerations she looks at in deciding whether or not to pursue an elder financial exploitation case or a potential criminal neglect case. She talked about how there needs to be a plus factor in some of these cases. And so, for example, oftentimes the neglect cases are ones where, in addition to neglecting the older adult, the son, daughter, or caretaker may also be financially exploiting their parent or grandparent, and that is a potential factor. A couple other things that Jane mentioned that I think are worth noting. One was the fact that it is not uncommon for the older adult not to want to have a decision-making capacity assessment done, or to cooperate with law enforcement and the prosecution, or to even want to see their child or grandchild prosecuted. This is an entirely not uncommon situation, and there could be incredibly valid reasons for why they do not want to cooperate or do not want the prosecution to proceed. In the case of the elder neglect example that we talked about yesterday, it is very possible, for example, that Mrs. Peach did not want to go to a nursing home and would rather live with her son, even under those horrible fact scenario that we put forth, rather than going to a nursing home. And that makes total sense. And so again, as Nina reminded us to do at the very beginning of the symposium, we must always sort of bear in mind what the older adults' wishes are and their perspective. Having said that, there are also times when crimes have been committed, when the circumstances are so dire that a prosecution is appropriate. And in those cases, it is critical that prosecutors understand that a capacity assessment, if it's not done, if an older adult does not choose to have it done, that is not the end of the story. Both Jane and Judge Young emphasize the fact that there is a constellation of evidence. And while it may be more difficult and more challenging for the prosecutors, we can bring those cases to the extent that for whatever reason, the older adult chooses not to engage and doesn't want to have the capacity assessment done. It's harder, yes, but can it be done? Yes, and it should be done. There are times when crimes have been committed and the rights of the older adult must be vindicated. Randy, our clinician, did a phenomenal job talking about, gave us a peek underneath the tent about what a capacity assessment evaluation could look like. He gave us a number of very, very helpful hints and suggestions about what lawyers should look for when hiring and retaining an evaluator to do a decision-making capacity assessment. He talks throughout the symposium, a number of people have noted the fact that there are lots of people out there who are doing these things, some of whom are obviously very, very qualified, but many of whom are not. And therefore, Randy gave a number of very helpful tips in terms of what lawyers should be asking, thinking about, looking for in who they hire. Another point that Randy made that I think bears repeating is the fact that when conducting the capacity assessment and trying to assess older adults' financial decision-making capacity or anything of that ilk, the decision itself is not dispositive of the question. In other words, he looks at the entire process of how the older adult reached that decision. Just because an older adult or anyone reaches a decision that we may disagree with, oh, how could you choose to live in squalor? How can you choose to give away all your money? That in and of itself is not the end of the question. And so Randy was very, very clear that the process through which an individual makes those determinations, makes those decisions, is what matters for his capacity assessment, and that the decision itself is not in itself the end of the inquiry, which I thought was important. Lastly, Judge Young took us home and gave us an invaluable insight in terms of how she, as a judge, views these cases, weighs the evidence. She echoed a point that Eric made on the first day about the dangers of leaps of logic and how the judge, as the gatekeeper of evidence, has to be mindful of looking and seeing whether or not the clinician, when offering his or her testimony regarding an issue, is doing so appropriately and within the boundaries of what the evidence and the capacity assessment offers. Again, I think she was very, very, Judge Young, for those of you who were not able to attend yesterday, has a wealth of experience, having been a prosecutor herself and having prosecuted elder abuse and elder fraud cases. So she is unique. Not all judges have the benefit of that deep experience. And therefore, she noted the fact that judges rely upon the litigants, upon the government and prosecutions, or the civil lawyers to flesh out all the facts and to explain, to the extent that a capacity assessment is being used, what it can be used for and its limitations, because we cannot assume that judges will know these things automatically. And so again, I think that was a helpful reminder. Judges are not omniscient. They do not know everything, and they do not know all the nuances of the MOCA or these capacity assessments. And so there's a lot of education that has to be done to make sure that these assessments, to the extent that they are admitted as evidence in a case, are given an appropriate amount of weight. Not too much, not too little, but an appropriate amount of weight. A couple of just final things regarding the criminal panel that I think are worth noting. One, again, I think everyone emphasized the benefits of collaboration and of MDTs. We talked about the fact that not every jurisdiction, not every area can have an MDT, but these interdisciplinary discussions are absolutely critical in making sure that every link in the chain is working properly. One other thing that came up during the discussion was the challenge of the fact that not all doctors want to conduct capacity assessments or to opine on these issues. Eric also noted on the first day the fact that this is not a well-compensated area, so that there is a real dearth out there of qualified evaluators, no matter the discipline. And so again, this is food for thought for us as we go ahead and proceed, what we're going to do to try to fill in this gap, to make sure that there are enough qualified people out there who can do financial or other types of decision-making capacity assessments. Before turning it over to the panel, I also want to just talk briefly about the discussion, the participant discussion that took place after the criminal panel, which was unbelievable. Over 800 of you stayed afterwards, after already a long day, to talk about various issues. And I thought we didn't tape the session because we wanted people to talk freely, but there were some themes that I thought are worth mentioning. One, clearly the most popular topic was regarding guardianship. And so it's well-timed and really lucky to have a tremendous panel who's going to be able to delve into some of the nuances of the issue that were talked about yesterday. Another issue that came up was regarding capacity assessments themselves and how sometimes they may not be culturally sensitive. And there may not be enough cultural competency in those who are administering the capacity assessments. And that's something that we need to be mindful of. Likewise, on a related note, someone mentioned the fact that we have to make sure that the capacity assessments or the instruments that we use are trauma informed. Again, we're talking about people who may have been victimized in the first place. And obviously we want those instruments to be done in a sensitive sort of way. Two other points. Again, someone mentioned the importance of collaboration and how lawyers oftentimes want to challenge bad science and bad capacity assessments, but don't know how to do so. And therefore, there is a training and education gap there that needs to be addressed, and that we should do more to try to arm attorneys when they're trying to help inform the court about the appropriate way to be given these types of instruments and these types of assessments, that there's a real information gap and there's work to be done there. So with that, that was day two. And that was, again, a robust discussion. And we were thrilled that so many people stayed on afterwards to share their views and experiences. But with that, I have the pleasure of introducing at least the moderator for the next panel. Today, the moderator will be Edwin Walker. Edwin is the Deputy Assistant Secretary for Aging and leads the Administration on Aging within the Administration for Community Living at the Department of Health and Human Services. Edwin has devoted his entire career to advocating for older adults. I consider him a colleague and a friend, and I'm honored that he was able to take the time to join us today and to lead this very impressive panel on today's issues. So Edwin, with that, the floor is yours. Thank you.
Thank you so much, Andy. I am so excited to be here. This is an incredible symposium. I've heard wonderful things about each day from other participants, and Andy's just giving you a tremendous summary of the issues and what's been going on. But today you're in for an additional treat because we have the best panel. And so we're just really excited to be partnering with the Department of Justice related to these issues. Today, we're really going to be discussing decision-making capacity because we know it's a key factor in many civil cases that involve elder justice issues, including guardianship, will contests, and suits to compensate victims of financial exploitation and other matters. Today, as I indicated, we have a terrific panel of experts to discuss decision-making capacity issues that arise in civil matters. These panel members represent the key professions that play a role in these cases, like judges, civil attorneys, adult protective services, and clinicians. Our panelists will discuss a number of key issues, including how decision-making capacity affects their respective professional activities, what professionals need to know about decision-making capacity, how to assess the qualifications of clinicians, how clinicians do and should assess capacity in civil cases, how professionals can collaborate, and whether there are policy or practice changes that would enhance elder justice and whether we need additional research. Our session today will stress best practices for promoting the dignity and independence of older adults to the maximum extent possible. So I'd like to begin by giving each panelist a chance to say hello and to tell you a little about their work and their roles. Each panelist will introduce themselves, tell us their profession and current position, and explain how decision-making capacity issues arise in their work. Then I'd like each panelist to name one key challenge they face when capacity issues arise in elder justice cases that reach the courts. In other words, I want the panelists to tell us in a sentence or two what keeps you up at night. So let's begin. And I'd like to begin with Judge Holland.
Good morning. For those of us on the West Coast, as you can tell, and good afternoon for others. My name is Lauren Holland. I use the pronouns she and her. I'm a circuit court judge for the state of Oregon. Born and raised in Chicago, moved to Oregon in 1972 and have been here ever since. I graduated from the University of Oregon Law School in 1978, practiced law for 14 years, was a partner in my own law firm doing a general law practice. I was elected to the bench in 1992. This is my 30th year on the bench. I sit on a court of general jurisdiction and hear all kinds of cases, criminal cases, civil cases, domestic relations cases, and for the last 20 plus years, all of our guardianship and conservatorship cases. There are over 900 open cases in Lane County on guardianship cases, and I work with judges around the state on the over 14,000 cases throughout our state. I work on the local, state, and national level on these cases. I've taught seminars at our local law school on guardianship cases and provide education and best practices to our state judges. I have worked with legislators on guardianship issues, education, testimony about bills regarding standards for fiduciaries, decision-making standards for fiduciaries, the need for monitoring, funding for court-appointed attorneys, review of the statutory guardianship framework. I'm chair of our Oregon Wings, which is an interdisciplinary working group on guardianship issues, and I serve on the ABA Commission on Law and Aging and was fortunate to be a delegate to last year's National Guardianship Summit. Briefly, capacity issues arise in all kinds of cases that I hear, not only guardianship cases. And each type of case may have a different standard based upon the purpose for which capacity is being determined and based upon the statutes. In criminal cases, which we heard about yesterday, there's three areas that capacity arises. Capacity of a defendant at the time of a crime, capacity of a defendant at the time of the charges and the trial, which is often called aid and assist, and capacity of the named victim in cases where consent, ability to consent are at issue. In civil cases, I hear cases, personal injury cases, where a plaintiff will bring a complaint that they've suffered damages in the form of a brain injury or an aggravation of a pre-existing cognitive impairment caused by the defendant. I hear elder abuse restraining order cases where another person applies to be a guardian ad litem for the elder, alleging that the elder is incapacitated but does not have a guardian, and that they should be appointed as guardian ad litem to be able to petition the court for a restraining order on behalf of the elder. I hear domestic relations cases where a petitioner may be taking or attempting to take a default against the respondent, yet states that the respondent lacks capacity, or where both the petitioner and respondent appear in court for the day of trial, and either from the beginning of the trial or as the trial unfolds, there are questions about the ability of one of the parties, sometimes both, but more often one of the parties, to understand the proceedings. And then there are also guardianship cases where capacity of the respondent is the focus of the case. The key challenge when capacity issues arise are the ethical and really legal considerations for lawyers. That's what I see. Who is your client to the lawyers? And remembering to start and end with the law, the statutes, the elements that must be proven in order to prevail. No other agenda. What keeps me up at night? Getting the decision right. Knowing that the decision that I make may profoundly impact the life of another human being. Thank you.
Thank you so much, Judge Holland. Now let's go to Charles Golbert.
Charles, you're muted.
Charles, you're on mute.
Thank you. Good morning, good afternoon to everybody, depending on where you are. I'm Charles Golbert. I'm an attorney. I serve as the Cook County Public Guardian. Cook County includes Chicago and all of the surrounding suburbs. It's one of the largest and most diverse counties in the country. We serve as the last resort guardian for about 700, mostly older people, although we serve some younger people as well. I went to law school here at Chicago, Northwestern. I'm also involved in a lot of guardianship activities, both locally and nationally. And guardianship is a subject I've written about both in law journals and op-eds. And capacity issues in our practice arise not just every day, but literally throughout the day in many, many contexts. And a few of those contexts are, of course, guardianship determinations, but also financial exploitation cases. Does somebody have capacity to give an alleged gift? Do they have capacity to sign these financial instruments? And we'll be talking about how it arises in financial exploitation context in more detail shortly. It also arises in healthcare surrogate decision-making. Even though we're the guardian for somebody, if they have the capacity to understand a medical procedure, they still get to make that decision themselves. Really, everything we do, there are capacity determinations. And some of the key challenges, what keeps me up at night, the biggest thing that, one of the biggest things that keeps me up at night is we know that there are a lot of people out there isolated in the community who need help and need assistance, and they're not discovered by authorities. They're not referred anywhere until after harm or mischief has occurred, which could be abuse, it could be financial exploitation, it could be their medical needs not being met. And that's the one I'll pick for that.
Thank you so much, Charles. Okay, Alison, I know you very well, but could you introduce yourself to this wonderful audience we have today?
Thank you very much, Edwin. Sure. I'm a lawyer and director of the Michigan Elder Justice Initiative. Our office advocates on behalf of older people and people with disabilities, and we engage in both individual representation and advocacy and systemic advocacy for that population. I've spent my whole career as a legal services lawyer advocating for these vulnerable individuals. Our staff of lawyers and ombudsmen come across capacity issues every single day. And I think I agree with Charles. It's not just once a day, it's throughout the day. So we're always evaluating whether a client has the capacity to form an attorney-client relationship or direct litigation, whether they can execute powers of attorney or other documents, whether they can make medical decisions, including whether they want to leave the nursing home or even get a COVID vaccination. And importantly, whether they have the capacity, sufficient capacity that they could prevail if a guardianship petition is filed against them. The issues we'll be discussing today are really sort of bread and butter in my office, and it's delightful to be here with all of you talking about them. What keeps me up at night is knowing that so many people are stripped of fundamental and basic rights to control their lives with, and here I'm quoting a Utah Judicial Commission, all the procedural rigor of processing a traffic ticket. That's what really keeps me up at night. So thank you.
Thank you, Alison. Now let's go to Rima Rivera. Tell us a little bit about your work.
Rima, you're muted.
We're still not hearing.
Of course I am. Can you hear me now? Okay, great. So thank you, Edwin. Thank you for, I'm so happy to be included on this panel today. I'm here on the East Coast. My name is Rima Rivera, and I'm a licensed social worker and a regional director for the New York City Adult Protective Services Program. That's commonly referred to by its acronym APS. So New York City APS is state mandated to assist individuals over the age of 18 who, because of a mental and or physical impairment, cannot protect themselves from harm, which can include abuse, self-neglect, or financial exploitation. And they have no one able or willing to assist them in the community. And that includes any other service provider. Like Charles and Alison, APS is faced with decision-making capacity issues every day. It's pretty much woven into the fabric of our work. We are charged with keeping vulnerable adults safe in the community. And we have an obligation under state social service law to provide services involuntarily if we find there is an imminent risk to the safety and well-being of an adult who we believe is incapable of making choices on their own behalf, while keeping in mind that an adult has a right to self-determination, remembering that an adult has the right to make poor decisions if they wish or decide how they want to live, even if those decisions continue to put them at risk. So that's something that keeps me up at night. And one of another big challenge that I always consider is that it's often believed that APS oversteps when we seek involuntary services, while at other times we face concerns that we don't do enough if we conclude that involuntary services are unwarranted. And that's a big challenge that we face, especially when interacting with the community. Thank you.
Thank you, Rima. And finally, we have Bonnie Olsen. Could you tell us a little bit about you and how these issues arise for you?
Thank you, Edwin. Yes, I'd be happy to. I'm a clinical neuropsychologist and a professor of clinical family medicine at the University of Southern California. I spend a fair amount of my time doing research on elder mistreatment in various ways, but especially focus on the context of mistreatment as it occurs in dementia. Decision-making capacity issues arise in my work regularly. I spent a number of years conducting capacity assessments in the field to assist agencies such as APS and sometimes law enforcement when there's a criminal matter being investigated. And that was often through the Orange County and the Los Angeles Forensic Centers, where we partnered with those agencies to conduct those assessments. I'm also frequently hired by either civil or attorneys or prosecutors when there's issues of capacity involved in an elder abuse case. And that almost exclusively is in order for me to form an opinion to help support, or as the case may turn out, not support the matter at hand. I also sit on the Judicial Council for Probate and Mental Health Subcommittee for the state of California, which I'm delighted to do, as this year the council is taking up the issue of revising the capacity assessment form that's used to communicate with the court from clinical providers. So the issues that keep me up at night are really this question of whether I've really, after conducting an assessment, whether I truly understand the client's values so that then I can integrate that into my opinion about their capacity, and whether I balance that issue of self-determination versus protection adequately. And then I also worry at times, what evidence has not been provided to me? What's been kept from me that might have changed my opinion had it been provided? Thank you.
Thank you so much, Bonnie, and thank you to each of you. And now we really want to get into the meat of today's session. We're going to be exploring the issues through 3 case scenarios. For each scenario, I'll read the fact pattern and you'll be able to see a brief account of the scenario on a slide. Then the panel will discuss the case and we'll get to weigh in on the relevant issues. We're going to save a few minutes at the end of the session for questions, so please know that there are hundreds of attendees and there's just no way we'll be able to get to everyone's question. But if you will put your questions in the chat, our team will read a few of them at the end. So let's kick this off. Karen, could you please put up the first slide? And our first case is a guardianship case. Mr. G, there we go. Mr. G is 76 years old and he resides in a nursing facility in a Midwestern city. He's never been married or had children, and his closest relatives are 2 nephews who live on the East Coast with whom he had little contact since Mr. G hadn't gotten along with her mother. He has had numerous physical health challenges or issues, including a stroke and diabetes, which resulted in amputation of one of his legs. He was transferred to the skilled nursing facility from the hospital a few years ago as a private pay resident. Mr. G fell behind on his nursing home payments because he was confused about his bill and didn't think he owed as much as the nursing home said that he owed. The nursing home social worker filed a petition for guardianship. She asked the nursing home's attending physician to affirm that Mr. G lacked capacity to handle his personal and financial decisions. The physician had met Mr. G briefly a couple of times, but had never conducted any cognitive screening or neuropsychological tests. The physician provided a 2-sentence letter filed with the court stating that Mr. G was post-stroke, confused at times, and lacked capacity to make financial and health decisions. Mr. G never received timely notice of the court hearing, which was held without his participation. A guardian from a small for-profit guardianship agency was appointed, and she proceeded to cash in Mr. G's interest-earning annuities, which he had intended to use to pay for his home care. Mr. G wrote a letter to the court stating he didn't want a guardian and wanted to return home, but he heard nothing from the court. The guardian sold his car and his house and refused to let him visit his home to collect his personal belongings prior to the closing. She rarely visited Mr. G and never participated in the care planning meetings. The long-term care ombudsman who visits the facility stopped by to see Mr. G one day. He told her he didn't want to be in the nursing home and he didn't want a guardian. The ombudsman referred him to the local legal services program for adults, older adults, that is. With Mr. G's consent, she also contacted APS to describe the guardian's actions and raised questions about what happened to the proceeds from the sale of this house. Karen, you can pull the slide down now. Let's get to a few questions for our panelists. We'll start with Judge Holland. If this initial petition for guardianship had been filed in your court, how would you have handled the case?
Where to begin? Let's start with some general principles in guardianship cases. First, in most, if not all states, there's a presumption that adults have capacity. Whether 19 or 91, the presumption attaches. It does not decrease as we age. It remains the presumption. Second, language is important. Each state uses its own terms. The same terms may have different definitions depending on the state. I've learned when working with a judge from another state on a case that we need to define the terms immediately just so that we understand each other. As an aside, wouldn't it be great if we started using some more respectful terms, such as person subject to a guardianship, instead of using the terms of one of my friends and colleagues, widows and orphans court, or the term ward? I'm just throwing that out there, but language is powerful and it reflects what we think of other people and how we treat them. So third, guardianship cases are a lawsuit. The statutes define the elements. For the petitioner to prevail, that is, to have their petition for a guardianship granted, they need to meet their burden of proof on each element, not what do I think is in the best interest of the respondent. That's not the standard. The guardianship cases often require a higher burden of proof than most civil cases. It is proof by clear and convincing evidence. And if the statutes allow for that or provide for that, if the petitioner does not meet that, then the guardianship cannot be granted. Oregon statutes and a number of other states as well allow a respondent to object not only in writing, but also orally. Why? Because it should be as easy as possible for a respondent to object. We are talking about another person making decisions about their life for them instead of them. These cases should give us judges pause before deciding to grant a guardianship, even when no objection has been filed. Most of us have the authority to appoint an attorney to represent the respondent if they don't already have their own attorney, and set the case for hearing, even without an objection filed. The decisions requested to be made by the guardian, and they need to be specified in the petition, may well be irreversible. Such decisions as involuntarily removing someone from their home, placing them in a facility for the rest of their life, decisions for a person to undergo surgery, such as an amputation, decisions to stop medical treatment, decisions to end life support. You may notice that I included removing a person from their home as irreversible. Here's why. My experience is that not infrequently, when a person is removed unwillingly from their home, and especially when their home is also sold, so there's really no hope that they will ever leave the facility, they do not live much longer. In this case, 5 issues jump out. Is this really a factual dispute about the amount owed to the facility that should be handled in another way? The timing of the petition raises questions, considering that Mr. G has been there for a few years. Second, where is the filed proof that the petitioner was personally served with the petition that should have been filed with the court, that he was given notice and time to object? Third, where's the court visitor report? I'm required under Oregon statutes, and I know a number of other states have these as well, to appoint a court visitor, independent, qualified, trained, all set out by statute, to investigate the allegations in the petition, interview the respondent in person as well as others, and write a report to the court. Fourth, where is the court-appointed attorney who represents the respondent and who, with her client, is present for the hearing, where rules of evidence apply, where the petitioner has the burden of proof by clear and convincing evidence that, 1, respondent is presently incapacitated. Note that guardianship is not a planning tool for the future. 2, that the proposed fiduciary is suitable and appropriate. And 3, that there are no less restrictive alternatives. Also, what is the evidence? The 2-sentence letter by the nursing home's attending physician, who is either employed by the nursing facility or has a financial contract with them. Either way, there's a financial bias. Certainly not a treating MD. He met Mr. G briefly a couple of times during the few years that Mr. G had been in this facility. And in any event, it's hearsay, although the doctor might be called as a witness. Who else would be testifying? Perhaps the doctor. I will note that we are conducting more of these hearings remotely, as COVID has taught us how to use technology to the benefit of parties to have better access to us. It's often easier for the respondent and other witnesses to attend. Attorneys for a respondent are now able to be with the respondent in person at the facility. And facilities are grateful to not have to transport someone to the courthouse, so they are using their technology as well to allow space for this to occur. It's also more efficient for expert witnesses. That was a question that was raised earlier. Please remember the law. The burden of proof is on the petitioner. If this is the evidence, doctor testifying, the petitioner may not be able to meet their burden of proof, and then the petition would be denied. The question was arisen, and I'll close with this, that would I as judge refer this or any other case to a clinician for a neuropsych exam or other full cognitive evaluation? This is an important question, so please bear with me. A number of jurisdictions allow courts to do this. I want you to consider that this should be done with caution and only for good cause. Why? Well, in civil cases and under Oregon law, rules of civil procedure, when the mental condition of a party is in controversy, the other party may file a motion with the court to order that party to submit to a mental examination, and the court may make such an order on good cause shown. In some civil cases, let's say a personal injury case where the plaintiff brings the lawsuit and alleges a mental injury or a brain injury that they sustained as a result of actions by the defendant, it is the plaintiff who is placing their own mental and physical condition in controversy. And then the defendant is seeking another expert medical examination. However, here, the respondent did not bring this petition. The respondent did not place their mental condition in controversy. It was the facility, and sometimes a family member can be brought, and they place the issue in controversy for many different reasons, ranging from great reasons to more nefarious reasons. The respondent did not place their own mental condition in controversy. And now the other party wants a full neuro exam. Where is the good cause shown with regard to that? Again, the burden of proof is on the petitioner, not on the respondent. Those are my first remarks. Thank you.
Well, thank you so much. And I'm actually going to reserve some time and come back to you because you certainly anticipated a number of the other questions that I was thinking of asking you. But I'm going to move on to Alison Hirschel. I'll come back to you in a minute. Alison, if Mr. G was referred to you or one of the attorneys you supervise, I want you to tell me how you would proceed. And when you answer that question, I'd also want to know whether or not there are any issues regarding Mr. G in terms of the capacity he had to perhaps even retain you and how you would go about handling that. Include any discussion of ethical rules that would guide your thinking in that regard.
Sure. Thanks, Edwin. I was really struck by this scenario, I have to say, because this is a situation that can and does happen in our state sometimes. I'm very grateful for the very thoughtful and careful way that Judge Holland goes about these cases, and I wish that all judges would follow suit. In this case, the first thing that we would do is go to visit Mr. G. There's absolutely no substitute for seeing someone for yourself, especially in his or her own home environment. And starting to build a relationship with that person. I think it's really important for judges to see the person they're ruling on as well. If Mr. G wanted our help and consented, we'd also want to start reviewing his medical and social services records and getting a better understanding of his goals, his strengths. Not just so much of guardianship is focused on deficits, but we want to focus as well on what his strengths are. What challenges does he have? What options might he have outside the nursing home? Now, I will say that because he has a guardian and not a supportive guardian, it can be a challenge even to see those records, but it's really important to comb through those carefully because they're going to come up in the hearing if there's careful consideration of his case. I agree with Judge Holland that it was really troubling that this case came up as more of a bill collection mechanism for the nursing home than an issue of his well-being. And it doesn't sound like anybody looked at whether there were less restrictive alternatives for him. Now, on the issue of whether he has capacity to retain us, in this case, I'd certainly have to know more than what we got in the scenario. But I feel like he is consistent in his desire not to have a guardian and not to be in the nursing home. He's able to take some steps himself, like contacting the court. And it appears that he does want help achieving those goals. So I wouldn't be too concerned in this case that he doesn't have capacity. I suspect we'd be pretty comfortable on that. On the issue of whether he could retain us to represent him in the guardianship hearing, Professor Nina Cohn, who spoke earlier in the symposium, wrote a brilliant article about all of the legal reasons why even a person under guardianship must be able to retain their own counsel. And I highly recommend that article to everyone. We look at Rule 1.14 of the Rules of Professional Conduct to see how to represent someone with diminished capacity, if in fact he has diminished capacity. And I'm not even sure because there wasn't a careful enough analysis of what's going on with him. And if we didn't think he had capacity, which I think is not the case here, at least enough capacity to retain us and work with us, then we'd start looking at other strategies. We'd hope that APS would follow up carefully on the possible exploitation. And we'd also work with our local ombudsman who have the power under the Older Americans Act to advocate for people who may not be able to consent to that help themselves.
Okay, so let's assume that all of that's in place. And how would you go about getting the evidence that he didn't require a guardian if you're going to refer him to a clinician to evaluate his decision-making capacity, how would you go about selecting one or choosing one? And what instructions would you provide to that clinician?
Sure. So as I said, it's really important to do a painstaking review of the records. The client himself or herself has to be really carefully prepared. You want to show them off to best advantage if you get to a court for a modification or termination of the guardianship. The court certainly didn't have good information on his capacity initially. So with his consent, and we would weigh the issues that Judge Holland raised about, is it really in his best interest to have an evaluation? But if we thought it was, and if he consented, we would look for a neuropsych evaluation or a social services assessment. But we would really want somebody who looked very carefully and who's willing to take a lot of time, who was skilled at these assessments or had a long-standing relationship with him, who was very open to looking at how he actually functions in his world, not just give us a test score or a diagnosis. That's not what we need. We need that clinician to really look at how is this person working, able to manage in their environment. And that can be a crucial aspect of the case. One thing I'll say is that sometimes a two-step process works well, so that the judge might be reluctant to just remove the guardian right away, but if we can substitute a friendlier and more supportive guardian, and that guardian works with the client to achieve more independence, then eventually, if that guardian supports the termination of a guardianship, we can file another petition, and the judge then might feel more comfortable. The one thing I'll say about the clinician is, you ask what kind of instructions I give. And I don't think I'd give very many instructions, because we would be selecting someone that we knew would be doing a thorough, professional, careful, respectful job, someone who's open to the idea that not all older people have, necessarily need a guardian. And so I just want that professional to do the very good job that we're reaching out to them to do.
Well, I want to ask another question then. What could be done about the previous guardian? I mean, and Mr. G's money and property. I mean, what action could be taken against it?
Yeah, we could certainly address that if the client wanted us to. So, I mean, there are a number of strategies we could use. We could ask for an accounting from the probate court. We could explore other possible legal action against that guardian. And there might also be actions that we'd want to take if we thought that this professional guardian was responsible for the lives of many people and was not fulfilling her fiduciary duty. There might be ways to report her or pursue her so that she couldn't, commit a disservice to all the other people whose lives that she's supposed to be managing. But that's definitely an issue. If our client wanted us to pursue it, we have a lot of tools where we could look at how to do that.
Well, as you know, within the Administration for Community Living, we take great pride in the Long-Term Care Ombudsman Program. This case scenario showed an ombudsman who referred Mr. G to legal services. Are there other things or other ways in which ombudsmen could get involved in capacity issues or guardianship cases?
Yeah, we are extraordinarily lucky because the State Long-Term Care Ombudsman Program is housed in our office, and that marriage of legal services and ombudsman has been incredibly fruitful and rewarding for all of us and really good for our clients. For us, the ombudsmen are a terrific source of case referrals, and these are individuals who might not have had any access to legal services before, but through the ombudsman, we get those very prompt referrals and can start talking to clients about representation. The ombudsman deals with issues of capacity all the time. It's a lot of what they're doing is helping nursing homes understand what rights residents have to make decisions for themselves, and to question if the nursing home is sometimes just ready to turn over decision making to somebody else, whether or not that person has actual legal authority. Really working with the nursing home to understand what rights a person retains and how to honor those important rights. Ombudsmen also occasionally testify in our guardianship cases, and they're a really good gut check for us because they often know the clients much better than we do. And, we might think, I'm a little worried. And the ombudsman can tell us, you know what, he was having a bad day that day, but he has been completely consistent for 6 months. This is why we really think it's a strong case. And that partnership, working with the ombudsman, who sometimes have more trust with the resident, for example, in a nursing home than we might have been able to establish yet. That's incredibly crucial and has helped us be really successful in these cases. So go ombudsman.
Great, thank you, Alison. Let's go to Charles for a second. As the public guardian, do you ever get involved in cases where, like in this case scenario, a different guardian had previously been appointed?
The answer is yes. About 12% of our appointments are successor appointments. The reasons can be a variety of reasons. It might be innocuous. The prior guardian died, say, but the majority of those 12% of our successor appointments is because there was some issue with a prior guardian. Most commonly, it's financial exploitation or concern of financial exploitation. The most common fact pattern where we become successor guardian has to do with accounting. So the guardian has to file an annual accounting. So here, this prior guardian would have to have accounted for what they did with the money from the sale of the house, what they did with the money from the sale of the car, and everything else. And in Cook County, there's a tickler system with the judges. If a guardian does not file an accounting within on time, they get a notice, and if they ignore the notice, there are further proceedings. And most of the 12% of the cases where we're appointed as assessor guardian is because the prior guardian does not file an accounting, and the court appoints a guardian ad litem, and there are concerns or suspicions of financial exploitation, or the guardian files an accounting that's just a mess. We can also be appointed sometimes if there are issues of care that the prior guardian is providing. So the answer is yes. About 12% of our cases, there was a prior guardian.
So what are the steps you would take to determine whether or not, like in this case scenario, Mr. G's property had truly been misappropriated? And what would you do to try to get it back?
So financial exploitation, so our office is very involved in financial exploitation recovery. About 40%, 40% of all of our new cases, there's some issue of financial exploitation. And as I mentioned, that number is even higher for successor appointments. And we have a unit of 3 lawyers. There are 3 very senior and aggressive lawyers, and their full-time practice is recovering money from that had been stolen from people before we were appointed as our guardian. We've been very successful. Over the last decade, we've recovered about $60 million on behalf of the people we serve, and then we're able to use that money for their care and benefit. In this case, the possible exploiter is a prior guardian. That makes our job easier because for a prior guardian, we can demand an accounting. The prior guardian has to account for what they did with the money they got for the car and for the house and for any other money that they collected. And any shortfall, we can get a turnover order. The other reason why exploitation cases involving prior guardians are easier is that in most jurisdictions here in Cook County, there has to be a bond. So if the exploiter spent the money on a new car, snorted the money, has a gambling problem, whatever, in cases without a bond, we can get an order, but it might be harder to actually get the money in pocket. But cases involving a prior guardian, there's a bond, and we can collect against the bond, and the bondsperson has the troubles of having to sue the prior guardian to get a collection. Other tools are citations to recover assets, and also all the other tools of civil litigation are available as well. And we'll talk more about some of those in our 3rd case study.
So Charles, I think I have one last question. So what are the factors that you consider in terms of whether you would take action to have a client's rights restored?
So this case would be a prime example. It's from the facts as presented, it's not clear at all that this person needs a guardian. We do move for restoration in appropriate cases. I would also say that in Illinois, petitions for restoration are very liberally interpreted. Our Probate Act actually says the request for restoration can take place in any form and are to be liberally interpreted. And the Probate Act specifically says a letter, a call, or a request. And the court takes those seriously and will appoint a guardian ad litem. And we, 2 things. So cases where we think are appropriate for restoration, we'll actually file the petition ourselves. And in cases where somebody under our guardianship requests a restoration, even if we disagree and do not think that that's appropriate, as a matter of policy, we will always report that to the courts.
Thank you so much. I'm going to jump to Rima for a second. You're the APS agency. So let's assume you have jurisdiction in long-term care facilities, because I know APS is different all over the country. Would you need to address the issue of whether Mr. G has the capacity to decide where he should live, to make financial decisions, to accept services? And how do you go about doing it?
Of course we would. I know that Alison was hoping APS could follow up. And the question is whether we would have jurisdiction. But in New York City, Adult Protective Services does not have jurisdiction in long-term care facilities. So this is kind of an unlikely scenario. New York City APS cannot pursue community guardianship for individuals who are in an institutional setting. And sometimes we get contacted by the court when a private or family member guardian is negligent in their duties or have not qualified, when they feel that the family member or petitioner is not suitable to become guardian. The court can ask us to consider cross-petitioning so we can nominate a community guardian who would be more suitable and appropriate. But that's if the adult is expected to return or be maintained in the community. So in this case, rather than challenge the validity of the guardianship, I would think a more appropriate plan for Adult Protective Services will be to follow up with the local ombudsman and try to offer Mr. G legal referrals who can assist Mr. G in moving the court to vacate the guardianship due to what seems to be a lack of due process. It would not be APS's role to represent Mr. G to have the guardianship vacated, but let's just say this scenario had Mr. G living in the community, or there was a plan to discharge him back to the community, because you wanted to know how APS would address the issue of Mr. G's decision-making capacity. So I just first want to make it clear that Adult Protective Services workers do not have the ability to determine an individual's decision-making capacity. It is not part of their skill set. What APS would do is conduct a thorough and comprehensive assessment, making sure that they gather all the information available and pretty much document what we see, document what we hear, document Mr. G's living environment, if he's in his home, Mr. G's behaviors, what Mr. G has verbalized, can he communicate his wishes? We will obtain information from collateral sources, maybe call Mr. G's two nephews if they're willing to share information, or try and get medical personnel information if medical providers are willing to share. We could send our staff social worker to visit Mr. G and administer what we call an IDA, which is an instrument for decisional abilities. It's a tool that we would use to measure Mr. G's ability to kind of understand his situation, the risk of not paying necessary bills on a timely basis, and to see if he can appreciate the consequences of his actions and decisions. We here at New York City APS also have the benefit of having access to visiting psychiatric services. So an APS worker can request a psychiatric evaluation from visiting psychiatric services, and the findings can help us support or help us determine the need for involuntary services. And at the very end, we have to consider all the interventions available to Mr. G to keep him safely at home. Really considering and focusing on the less restrictive interventions, because as I read the scenario, it doesn't seem as if Mr. G is in need of a guardian.
Great, thank you.
I hope that.
Yes, and we're running a little short on time, so I have 100 questions to ask, and I know that all of our participants do as well, but I'm gonna move on to Bonnie, because, you know, when we looked at this particular fact pattern, I guess I'd like for you to comment on the evidence that was presented in this to the court on decision-making capacity. But in addition to that, could you also talk about what evidence should have looked at, what it should have looked like?
Sure. I think, unfortunately, this scenario and this fact pattern is not unusual. To state the obvious, physicians are really primarily responsible for providing medical care to their patients, and they're often stymied by legal issues that are presented to them, and sometimes not trained or don't have enough knowledge about how to approach it. Often physicians are more comfortable offering opinion and judgment about medical decision making, but less so about these sorts of legal things like guardianship. There are times, which I just want to mention because I think it's important, we're providing a brief documentation, such as like to a financial institution about an individual's, your opinion about an individual's capacity to make financial decisions, say, particularly if there's an instrument such as a power of attorney that's existing in place, and all it requires is sort of documentation of the lack of capacity to the institution that that's the situation. In that case, then the financial institution, the bank or whatever, isn't really privileged to how you arrived at all of that with all the background information and a very brief statement that a full assessment had been undertaken, and this was the conclusion. Obviously, though, for a guardianship, this is woefully inadequate. What would I have done had this referral come to me and I had undertaken a capacity assessment? I would have done all the things that have been talked about in the earlier segments of this symposium that should be included in a capacity assessment. Certainly, they're pretty universally, folks do a cognitive assessment, some sort of test that measures thinking abilities. I also want to interview the client regarding the decisions that are in question and do they understand what's going on and their ability to weigh alternatives and reason around whatever the decision is. In this case, it was to pay the bill for the nursing home. I want all the relevant information that's historical, whether that's medical or personal information that might be there. And I really want to be able to arrive at some understanding of what this client's values and what their preferences are, what kind of things, like what matters to them in their lives. In most states, there's a specific form that communicates the opinion of the experts process back to the court. In California, as I mentioned, it's currently under some revision, but the goal of that is really to align the content of your report and what you're giving to the report as the evaluator so that it provides the court adequate information to determine whether both this individual needs a guardian and is the proposed guardian the appropriate individual. I often will also offer opinion about whether there are less restrictive alternatives that should perhaps be considered instead of the guardianship. But universally, I'll report on retained capacities, not just what the individual can't do, but what they can do. And then if it's appropriate, if there are areas, I might opine to the court what might be areas to consider where they might be able to limit the scope of the guardianship. So that's sort of where I gather the information and what I do with it.
Great. So I'm sure we all have opinions about what this judge should have looked at. And I understand that you guys recently completed a project to assist judges in guardianship cases. Could you tell us a little bit about your guardianship evaluation worksheet and how it might have helped in this particular case?
Sure, happy to. This is a piece of work that we're quite proud of from our group at USC, and very happily I can say that the Department of Justice funded this. The result of the work is that we produced a 2-page fillable PDF document that's based on input from an expert advisory board and focus groups of probate judges. And then finally, we developed this tool and then piloted it with 50 probate jurists from around the country. The goal of the whole tool is to provide judges assistance. What it does is it aggregates evidence in probate matters in a systematic way. It helps them to identify when there's gaps in evidence, if there are any. It helps them to outline more or less what are the diminished as well as the retained capabilities of the individual. They can evaluate the risk that mistreatment or abuse can occur through the guardianship, because of course the judges choose or want to avoid that at all, if at all possible. And to identify alternatives to guardianship, things that might have been less restrictive, and to determine if those had been explored and exhausted. And then again, to consider areas where they may be able to limit the scope of the guardianship. And finding ways that really aligns with the goals and preferences and values of the client. What we learned in the work that we did, particularly in the piloting phase, was that judges who use the tool in their practice, and we asked them to do it on at least 5 cases, many used it in many more cases than that, is they reported back to us that they felt much more comfortable in the decisions that they were making. It at times helped them arrive at sometimes a different decision than they would have made if the tool had not been there, but just generally more comfortable. They were better able to evaluate the retained capacities of the client, and they had a clearer idea of what areas they may not want to extinguish rights in. And I just want to mention that we're going to be presenting the tool and sort of how to access it and how to use it in your court on June 21st through a webinar that's sponsored by the National Center for State Courts. So that's going to be disseminated broadly in a few weeks. So thank you.
That's great. I'm now we're really short on time, so I'm gonna ask you to keep your comments brief as we move forward. But I want to go back to Judge Holland, because we've heard a lot about trying to restore Mr. G's rights. And so what would you do different than if a petition was before you to restore his rights, then what would you look at differently than what you would look for in an initial petition for guardianship?
Well, thank you for the question. Unlike other cases where once a decision is made and a judgment signed, the case is over, in guardianship cases, if a guardianship is granted, the case is not over. Not for the respondent, not for the fiduciary, and not for the court. First, the judgment itself should set out only the authority that is warranted in the particular case. There was a question that arose yesterday, I believe, during a discussion among participants of what language could be placed into a judgment about the rights that the person retains. And I'm going to suggest that that be flipped, that all rights are retained by the person, and that the judgment set out specific authority as requested by the petitioner for the specific authority and decision-making that the guardian would be using in that particular case. Because I'm going to say that blanket requests for plenary authority really don't cut it anymore. They are not necessary nearly as often as requested. They are rarely necessary. So the court needs to, once, if a guardianship is granted, monitor the case, ensure that the annual accounting is timely filed and audited, ensure that a guardian report is read, reviewed, and that it encompasses the contacts that the guardian has made with the person under guardianships, the types of decisions that have been made, the actual decisions made. If your jurisdiction has the resources, there's also monitoring programs with use of monitors to conduct independent investigations. This is different from the court visitor requirement. But these monitoring programs for ongoing guardianships, either for random cases or targeted cases or both, we had the opportunity and the resources to be involved with that for a while. And I will tell you that as a result of those reports filed by the monitors, a third of those cases that were monitored and reports reviewed by my probate commissioner and then by me were terminated. A third were modified with regard to the authority, or the guardian was removed, and a third remained as it was initially under the judgment. The issue of restoration of rights, when that surfaces as a result of either monitoring, as a result of court review of the file, as a result of a request by the person under guardianship, what I would be doing is appointing an attorney, if there wasn't already one involved, for the person under guardianship, appoint a court visitor to investigate again and write a report to the court, set the matter for hearing, And at this point, the burden of proof remains on the party seeking to continue the guardianship. In Oregon, the burden of proof never shifts or gets transferred to the person who's the subject of the guardianship. I realize that's not the case in all jurisdictions. Some jurisdictions by statute transfer the burden of proof, not by clear and convincing evidence, but by a preponderance of the evidence to retain or to restore particular rights. That's not the case in Oregon, and I would urge persons involved in this to look at legislation that continues to have the burden of proof on the person who is seeking to continue the guardianship, that all of the elements requiring a guardianship are met in order to continue it. So it wouldn't be different from the original in terms of what the elements are. That's what I would be doing.
Well, thank you. Thank you all so very much. That concludes our discussion with regard to case scenario 1. So Karen, we want to turn to you to put up the next slide for case 2, which focuses on contesting a will. And I'm going to start the scenario. Mrs. A inherited $10 million from her deceased husband. We'd all like the $10 million. She was active on nonprofit boards and contributed generously to these organizations. Her estate plan was consistent for about 40 years. The money in a trust set up for her by her husband would go to charity per her instructions. Of her remaining property, several million would go to her only son, Mr. M, and a significant chunk would go into a trust that would provide a stream of income to her son, but eventually go to charity. She appointed her son and her longtime attorney from a prominent law firm as co-executors of her will. In her late 90s, Mrs. A was diagnosed with Alzheimer's disease. She also had declining physical health, eyesight, and hearing. She often did not recognize friends and family members, and sometimes asked her home health aide to identify documents for her after she had signed them. About 4 or 5 years after her Alzheimer's diagnosis, Mrs. A's son, his wife, and Mr. F, a lawyer who had befriended Mrs. A, began meeting to discuss making changes to her will. Her longtime estate lawyer received a letter signed by Mrs. A saying he'd been replaced, and the family refused to let him see Mrs. A. Mr. F asked a new lawyer to draft changes to her will. These changes meant that Mrs. A's son would inherit a lot more money outright, would be able to direct property to his wife, and would become the sole executor. The new lawyer, who never met Mrs. A but had been dealing with her son, came to see Mrs. A just once for a half hour to explain the document and to have her sign it. In addition, Ms. A's aide was concerned that some of her jewelry and art had disappeared. Mrs. A's alarmed grandson suspected that his father and his father's current wife were taking advantage of Mrs. A. He is reluctant to contact Adult Protective Services, however, because he doesn't think they get involved in a case involving this much private wealth. Ms. A died soon after his suspicions were raised. When his father began probate proceedings, Ms. A's will was challenged. So Karen, you can now take down the slide. And I'm going to go to our panelists. And the scenario we want to add here is that the law firm of Hirschel and Goldberg is representing, handling the will contest. So Charles, I'm going to start with you, and I'm going to give you a series of questions here. How would you obtain evidence that Mrs. A lacked capacity to execute the will? What exactly, in describing this, tell us what testamentary capacity is and what undue influence would be an issue?
So why don't I start with what testamentary capacity is? It's the lowest form of capacity. So for example, people under my office's guardianship may well still have testamentary capacity because it's the lowest burden of capacity. And in Illinois, there are 3 elements, and it's similar in many, many states. First, you have to be able to know and understand the natural objects of your bounty. That just means who your heirs are, who your friends are, who your family members are. 2, you have to be able to understand the kind and character and value of your assets. And that's kind of a rudimentary understanding. You don't have to know your checking account balance to the nickel. You don't have to know the most recent Zillow appraisal of your house. It means a basic understanding. I have a house, it's probably worth about $500,000. I have some checking and investment accounts. They're probably worth a few $100,000. And I have a safe deposit box. Pretty lower standard. And 3, you have to be able to make a disposition of the property according to some plan. Again, it doesn't have to be the legal minutia of a plan of an estate planning lawyer. It can just be, I have 2 children, I want them each to get half. Pretty easy, a lower standard of capacity. In terms of evidence, when we're putting together our theory, what lawyers call the theory of the case in an incapacity case, we're looking really at 2 different kinds of evidence. One is medical evidence, and the second is what I call environmental or anecdotal evidence. So for medical evidence, the fact pattern says that she had a diagnosis of Alzheimer's in her 90s. So I want to learn about that diagnosis, get all the medical records surrounding that. I want to talk to the doctor and the medical care providers. And then in addition to that, I want to get all of her recent medical records. I'm looking for references to confusion. I'm looking for references to orientation and so forth. And that's the type of medical evidence that I'd be looking for. But in addition, part of the story I'm going to tell to the trier of fact, part of the theory of the case is also going to involve environmental and anecdotal evidence. So I want to talk to the care providers about her ability to understand things. The care providers' statements that she would often ask them to explain what documents were and what documents meant only after she had signed them is something I really want to explore. I'm going to talk to the son. I'm sorry, to the grandson who has information. I'm going to depose the lawyers who prepared this. I'm going to depose the son who apparently arranged this. And through the medical evidence and the environmental anecdotal evidence, I'll start to be able to tell the theory of the case's story for the trier of fact.
Thank you, sir. So I'm going to go to the other half of this law firm and turn to Alison Hirschel. And a couple of questions here. Are there ethical issues concerning the lawyer who wrote the most recent will? Who was his client? Can the lawyer represent both the son and the mother in this situation? And what really should have been done to ensure that Ms. A had testamentary capacity as Charles described? Did she have the capacity to retain him?
Thanks, Edwin. Those are great questions, and I'm honored to be the fictional partner of Charles in this fictional law firm. But clearly there are alarm bells all over this scenario, as there were in the real case that this was based on. One of the most striking things to me was the fact that the new lawyer had clearly drawn up the whole will with its striking changes of her estate plan before he'd ever met with Ms. A. And if the lawyer had been appropriately treating her as his client, then he would have wanted to engage in long and careful conversations with her before any document was ever drawn up. And because the document is supposed to represent her wishes, particularly in a case like this, where there is reason to be very concerned about her capacity, that lawyer needed to spend a lot of time with her. She had been diagnosed with Alzheimer's a number of years before. She was clearly showing signs of cognitive impairment. And every ethical lawyer I know would bend over backwards in this situation to make sure that she had capacity to execute a new will, as opposed to just drawing up what the son wants and producing it for her to sign. I also thought there was a real red flag that the longtime lawyer was dismissed and not even allowed to talk to her. It's possible that she was saying she didn't want to talk to him. We don't know that, but otherwise it seems very concerning that he was just cut out as this new plan, which benefited the son, move forward. It's her estate, so she is clearly the client, and it's her property to dispose of. So in doing the son's bidding, I think the lawyer was absolutely violating his ethical duties. And there are questions that would arise, like a conflict of interest, undue influence, confidentiality, and many other concerns in this scenario. It certainly sounds like the lawyer was a zealous advocate for the son, but not for Mrs. A. I think, there are lots of things that could be done to ensure that Ms. A does have testamentary capacity. And we've already talked about a number of those things. But as I said, I think ethical lawyers would go through many, many, many steps before they felt comfortable having her in the situation we understand her to be in, execute that will.
Thank you so much. All right, Bonnie, this incredible law firm has now retained you, Dr. Olsen, to testify in this kind of will contest. Now, you've never met Ms. A, but the lawyers provide you with medical records as well as written accounts of Mrs. A's home health aides, her friends, her other relatives about her behavior and her habits. So my questions for you are, can you testify regarding Mrs. A and her testamentary capacity when she signed the will? And how, as a clinician, do you go about assessing whether someone had capacity years later or even after death?
Well, this is a really complex question for a clinician, and at times it's possible to form an opinion that is defensible and solid, and there are other times when there just simply isn't enough evidence to really come to a solid opinion on it. But as you suggested, I would want to partner with a law firm and make sure I had access to all the documents that they have accumulated. And I often will work with civil attorneys to sort of tell them what, in addition, would be useful to me to help me form my opinion. So it may be tracking down neighbors or friends or people, associates of the individual at the time when they signed the document, so that they can tell me indirectly how they perceive the individual was functioning at the time. So I do all of that sort of work, interview people and gather all of those documents and review them really carefully. I often will review depositions of people so that I can hear in their own words what it is, how they characterize her functioning at the time. The goal would be to flesh out the characteristics and the capabilities of the decedent or the individual at the point in time when those documents were executed. And if I can form a solid opinion, I can offer that, and then I can offer testimony to support it. What I won't do is, if there isn't enough evidence, is to give an opinion that is not defensible. That doesn't help anybody in this sort of a process. So it's sometimes an achievable outcome, and other times it's just simply not.
Thank you so very much. All right, now Judge Holland, this case is going to land right in your courtroom. So tell us what kind of evidence you're going to look for, and are there issues regarding admissibility of evidence, particularly around the capacity assessment report and the clinician who conducted the evaluation? And is evidence of dementia and the dementia diagnosis relevant?
Thank you for the questions. You're absolutely right. What we're looking at and having to determine is what was the capacity of the decedent at the time she executed this new will. No doubt she would have discussed her plan, her planned giving with, and her estate plan with the charitable organizations under the previous will. And most likely, how would this come to court? Most likely one of the charitable organizations, or maybe several or all of them, would bring the will contest. That's because they are saying that they are losing out as a result of this new will, and the court should void that will, set it aside, and go back to the will that was executed at an earlier time. Interesting about the grandson, it's questionable, and there could be raised a question of standing, of whether or not a grandson who was not in the first will either and wasn't a beneficiary of the first will would have been in a position to bring the will contest when he's not losing anything out from this new will. But certainly the charitable organizations are, and I've had enough cases where they bring the will contest. So the will contest could certainly be brought under a claim of undue influence by itself, whether there was testamentary capacity or not, because that is not an element of an undue influence case. It could also be brought under a claim of lack of testamentary capacity of the decedent, or it could be both. In the undue influence case, what you're looking at is initially a confidential relationship between the proponent of the new will and the decedent, and then also other suspicious circumstances. Was there independent counsel for the decedent? Certainly in this case, there wasn't. Did the person who, the proponent of the new will, participate in procuring the new will? And it appears that he did. Was the will prepared in secrecy or in haste? We haven't heard very much about that yet, although there certainly weren't discussions between the new attorney and the decedent at all with regard to what her desires are and her thoughts were and what she wanted to see happen with her money. Was there a change in the decedent's attitude towards previous beneficiaries? We don't have any information from the charitable organizations that there was a falling out, or from the son or from other family members that something occurred whereby it made sense that she no longer wanted to do her giving to that organization. Was this an unnatural gift or an unjust gift given in the new will? And what was the decedent's susceptibility to influence by the son? And that also talks about her capacity that gets involved. I agree with the comments that were made that it would be very difficult for a clinician to go back in time, not having done any type of an assessment with regard to this particular woman when she was. I'd certainly want to hear from all of the people that she was, just talking about, that Dr. Olsen was just talking about, because whether it's neighbors, whether it's friends, whether it is people who knew her at the time, I'd also want to hear from the first lawyer in terms of what was going on, what her mental capacity was. When was that will? Was that will from 10 years ago? Was that will only 4 years ago? When was that, and what's the time differential between what we're having then and what we're having now? Issues of undue influence also can occur when the person is alive and has given transfers of property, or perhaps, other types of land or real estate or whatever it may also be. And there is a family member who's attempting to set that aside based upon undue influence. So that happens as well. There was information that came up the other day with regard to lawyers, estate lawyers. It was brought up that lawyers might perform themselves some type of a mini mental exam or ask for a letter from a treating physician at the time of execution of the will to substantiate somebody's cognitive ability. I would caution that to this extent. If a lawyer does that in every case when somebody is going to execute a will, then that is the nature of what they do in their office practice. And that can't be questioned. If, however, the lawyer only does this for certain clients, I think it leaves the lawyer open and question about what caused the lawyer to do so. Did the lawyer themselves have some question about the ability of and the capacity of that person? And I think it just leaves open further examination with regard to the doubts the lawyer may have had with regard to testamentary capacity of that client. And that's come up in more than one case when there have been will contests before me. I'm not certain, going back to your question, that a clinician who is merely gathering information from a wide variety of lay persons and then is going to make a conclusion based upon that, that's an expertise that's going to be helpful to the court. I don't know if that's admissible. I think that there could be questions raised about admissibility of that, as opposed to having all of those witnesses simply testify in court, because then the court ends up having to make that determination.
Thank you so very much. Okay, Rima, in this case, as we know, no one contacted APS. Should they have?
I know. Of course they should have. So I want to emphasize that APS is mandated to assist anyone over the age of 18, but without regard to income and assets. So if an individual is found eligible and allegedly at risk of financial exploitation, APS will investigate the allegations, whether the alleged victim's sole income is a monthly Social Security benefit or the victim has a large amount of assets that are attached to a more complex financial portfolio. So we've addressed cases with similar circumstances. If Mrs. A had been referred to APS, we would have investigated and most certainly would have referred and discussed this case with our enhanced multidisciplinary team. Adult Protective Services in New York participates in bi-monthly enhanced multidisciplinary team meetings where we collaborate with community partners and elder abuse stakeholders that include neuropsychiatrists, geriatricians, forensic accountants, legal services, and law enforcement, including the DA's office. And I'm sure the DA's office would have been very interested in this case.
Rima, I'm sorry to interrupt. It appears someone has an unmuted mic. We've done our best to identify and we can't find it. So I'm just going to ask all the attendees, please make sure your mic is muted. And I apologize, Rima, and Edwin, back to you.
Okay, well, I'm finished. Thank you, Edwin.
Thank you so much. So that concludes scenario 2. So Karen, could you please show us the final slide for this panel? And case 3 relates to financial recovery after theft of money and property. The scenario is, and I'm going to go on and start while Karen puts it up. Mrs. W is an American of Japanese ancestry. She spent 2 years after World War II in an internment camp in Arizona. After the war, she earned a bachelor's degree in Chicago and moved to Washington, where she worked for 3 decades for the U.S. Department of Health and Human Services. Good choice. She saved a lot of her money and moved back to Chicago when she retired. She has no living family. After a fall and declining health, Mrs. W moved into an assisted living facility. While living there, she developed dementia. Over time, employees of the facility, including the business manager, activities director, receptionist, and hairdresser, stole $600,000 from her, which represented virtually her entire life savings. Her money and property disappeared in different ways. Jewelry disappeared. She signed checks made out to different members of the staff or to cash. Rent was sometimes paid twice. She went with staff members to her bank. She named the activities director her agent under power of attorney. Finally, a new bookkeeper at the facility became alarmed and notified APS of the situation when Mrs. W couldn't pay her monthly bill. The court appointed the public guardian to serve as her guardian. After moving her to a different facility, the public guardian sued the previous facility, its parent company, and the individual employees to recover her funds. So Karen, you can now take down the slide, and I'm going back to Rima, APS. You are notified about the report of these huge financial losses. How would APS proceed in a case like this? Would you be likely to obtain a decision-making capacity evaluation? Could APS testify in a case like this if it went to trial?
In this scenario, in order for APS to pursue guardianship, they are first would have been a comprehensive assessment conducted, and Ms. W would have had to been found APS eligible. So this is another case where we may have introduced this to the multidisciplinary team and had the forensic accountant undergo a financial review. So if APS pursued an appointment of a community guardian to recover funds, the community guardian would most likely have to make a referral to the DA's office because they may not have had the financial resources to follow through with a civil action, for instance, hiring an attorney. So unless Ms. W had the finances to do so, this case may have needed to go to the district attorney's office. In addition, the judge would have to order the guardian to sue the facility. So if there was a community guardian appointed, it would have to be part of the order. The judge would have to order the guardian to sue because the guardian's powers are limited to only address those activities for which the person needs assistance for. So in this scenario, the guardian was successful in transferring Ms. W to another facility. So perhaps I'm thinking that the receiving facility can also attempt to recover the funds from the assisted living facility in question if they are reliant on the funds for payment. So of course, there would have been a decision-making evaluation. During our assessment, Ms. W, based on what she has told us, based on what we've witnessed, based on the information we would have received from collateral sources, APS would have procured a psychiatric evaluation through our visiting psychiatric services. And that psychiatric evaluation, in addition to all the well-documented case record that we present, would be needed for us to pursue the appointment of a community guardian. And I think you also asked if APS would testify if this went to trial. We would testify if we're ordered by the court to do so. So if we're ordered either through a specific order or still ordered subpoena issued by the guardian, but we wouldn't be able to testify voluntarily on our own without that court order. I hope that answered your question.
Thank you, thank you. All right, so Charles, you are the public guardian in this case. So issues of decision-making capacity would have been litigated in the guardianship case. Would you use that evidence in the civil case?
Yes, so I want to point out this is an actual case that my office handled. All the facts it's very similar. The only fact that's different is that it was actually $750,000 that was stolen from this woman, not $600,000. So the answer to your question is kind of, sort of. And what I mean by that is the legal inquiry it's similar, but it's a little different. So if the exploitation is going on, let's say in 2018 and 2019, and then this actually what happened was the bank finally became suspicious and called the police who referred it to our office. And so let's say guardianship happens in 2020, and then we file a civil lawsuit later on in 2020 or 2021. So at the guardianship hearing in 2020, the legal question is Mrs. W's capacity at the time of the hearing in 2020. For the exploitation recovery lawsuit, the issue's related but a little different. It's whether she had capacity in 2018 and 2019 when she was writing these large checks to the people at the taking care of her at the nursing home, when she gave her ATM card to them, when she, and so forth. In this particular case, the doctor who we used for the guardianship case, we did refer and we asked him to do a assessment of her capacity going back to when all of this happened. And it made sense here because it all happened in a pretty short period of time. Sometimes, though, we're appointed and we start going through financial records and we see exploitation that might have happened years earlier after the guardianship proceeding, and we might not have asked the doctor to be thinking of 3 years ago. In cases like that, we're more likely to use a different expert and be looking at evidence. So it depends on the case. The inquiry it's similar but different.
So could you just sort of describe for us or explain, the issues related to like financial capacity and donative capacity and consent? Could you clarify those for us? And you've already sort of talked about, possibly retaining a clinician. So talk about that as well in terms of, issues related to capacity on existing clinical and other evidence.
Okay, so you mentioned a number of different kinds of capacity. You mentioned donative capacity, and that is an issue in this case because what did all these nursing home employees say as their defense? They said, oh, these were all presents. Mrs. W wanted me to have a $100,000 present for my birthday. Their positions that these were gifts is untenable and unenviable positions because this nursing home actually had a policy that prohibited any of their staff from ever accepting gifts from any of the residents. And of course, this wasn't a $10 Starbucks card at Christmas. These were huge gifts, not gifts, checks and cash and stuff, thousands of dollars and tens of thousands of dollars at a time, adding up to $750,000. But since they were claiming it was gifts, and so donative intent is relevant. Financial capacity is relevant because she signed a power of attorney, which is how one of the staff members plundered her money. She signed checks. Actually, some of the checks were forged, but some of them it appeared she signed when she didn't have capacity. So all those different types of capacities were definitely relevant in this case. And in terms of how we're going to show this capacity, again, our theory of the case, that's just what lawyers call the story we're going to tell, the narrative that we're going to tell. Is going to be a combination of medical evidence. It's going to be a combination of environmental anecdotal evidence. So here, the medical evidence, she had dementia. The nursing home's own records, when we looked at it, documented very clearly her cognitive decline when she was a resident there. The doctor who did the guardianship capacity, again, we asked him to evaluate her capacity earlier when these transactions happened as well. The other thing we would look at, though, is so capacity is a medical legal decision, but of course, common sense doesn't go out the door when you walk into the courthouse. And what do I mean by that? So some of these transactions were ATM transactions. She was in her mid and late 90s at the time. She had a bank card, but she had never used it, not even once, for an ATM transaction before the nursing home staff start taking her money. And that's very common for a lot of people of that age. Oh, and by the way, these ATM transactions, they were not from the ATM down the street from her nursing home. They were from an ATM all the way on the other side of town, which just happens to be the closest, most convenient ATM to one of the exploiters. In addition, I mentioned the nursing home policy. They claimed these were gifts. She wanted us to have it, but that violated a clear nursing home prohibition against any staff accepting gifts from residents. Her history of spending. She was a government employee for her career, but she was always very disciplined about savings. She always lived a very frugal life. That's how she was able to accumulate this money to enjoy in her retirement. Then all of a sudden, precipitously, by the way, right when the dementia kicks in, you start seeing these huge transactions with the money benefiting the nursing home staff. A lot of exploiters, I'll say, are very stupid when it comes to their social media posts. So in this particular case, some of the nursing home staff were posting pictures of them boasting and trumpeting about new jewelry that they bought from Roger and Holland's, for example. And we looked online and found out how much this Roger and Holland's necklace cost, $10,000. Oh, guess what? That post was 1 week after that same person cut a check for $10,000 to themselves. That's all part of our narrative. That's all part of our theory of the case. Also, the Fifth Amendment played a role in this particular case. What do I mean by that? So several of the nursing home staff, when we deposed them, took the Fifth Amendment to every question we asked. Questions along the lines of, did you forge this check number 829 payable to yourself from Mrs. W's account for $50,000? I plead the Fifth. Did Mrs. W have capacity when she gave you this check? I plead the Fifth, and so forth. Now, in a criminal case, of course, no presumption can be raised from pleading the Fifth is their constitutional right. But in a civil case, to recover the money, the trier of fact, whether it be a judge or jury, can draw whatever inferences are appropriate from pleading the Fifth. And so, again, the narrative and the theory of the case develops. And the only other thing I would add is that these cases, they really, really offend triers of fact. Again, whether it be jurors or judges, they see themselves in whatever 10 years, 20 years, 25 years, and think about what can happen to them. We've had cases where we've gotten every nickel we've asked for in recovery, plus substantial punitive damages. So when presented with fact patterns like these, triers of fact get it. They understand what's going on.
Thank you. We're really benefiting from you litigating numerous financial recovery cases, including this particular one. Give us a general description of how you handle the capacity and consent issues, and tell us what trends you're seeing.
So again, we're going to be looking at the medical evidence. So she had a dementia diagnosis. There are the records from the nursing home chart that really, the nursing home's own records do a good job of documenting her cognitive decline. We had a clinician testify at the guardianship trial and also asked him to assess her capacity at the time of all of these transactions, which were shortly before. And that medical evidence, together with the type of environmental anecdotal evidence, that's how we demonstrate the incapacity at trial.
Great, thank you. So, Alison, from your perspective of a lawyer who handles elder justice cases, what issues do you see in this scenario with regard to decision-making capacity?
Well, I think that Charles has outlined a lot of the reasons why we have to be really concerned about her decision-making capacity. And it does seem to be a case of clear exploitation. But there are just three issues I want to tick off that I think we need to be careful about. The first is just that there's a blanket statement that she has dementia, and that really doesn't tell me anything because, dementia can, first of all, the diagnosis is sometimes slapped on people when it's not even appropriate, but it can range from moderate to severe. And so, I need to know much more than the fact that she had dementia to make a determination about what her decision-making capacity might be. The second issue is that sometimes individuals in this situation who have capacity really do choose to give the people around them gifts. Now, of course, the staff of this facility should not have accepted those gifts, and there was a policy in the facility that they shouldn't have. I'm not trying to encourage people to be exploited, but I do want to recognize that in this case, it doesn't appear that she had anyone else in her life aside from the people who were around her in that facility. And I think when we're looking at decision-making capacity, we have to at least think about whether this is something that she truly wanted to do and perhaps had the capacity to do. These facts don't seem to suggest that she did have that capacity, but it's something to think about. The last thing is something that I think we've been talking about quite a bit. We really need to ask capacity for what? Which decisions are we evaluating her capacity on? And we have to look carefully at whether she could understand. Maybe it's a very simple capacity decision to decide to give someone a modest gift. It's entirely something else to give someone $10,000. And I would agree with all the flags that Charles identified, including particularly the fact that she'd always been careful with her money. And now, as the result of all of these gifts, she was in a situation of real peril where she couldn't pay for care. And that says a lot to me that something that decision-making capacity is in real question here.
Great, thank you. Okay, Bonnie, let's assume that you did the initial decision-making capacity assessment associated with the guardianship proceeding. Your report is utilized in the guardianship case, and you're called to testify. In your state, and is there a form? Because your earlier form, the guardianship evaluation worksheet, I could see from the chat, it's very, very popular. Everybody wants it, and I think that the resource has been provided now. But is there a form you would have to fill out for the court, and can you describe its pluses and minuses?
Yes, absolutely. So in the state of California, we have a form that's commonly referred to as the CAPDEC, the Capacity Declaration, which essentially you're declaring to the court that the information contained in it is valid, that you're testifying to that. I think Laura Mosqueda on Tuesday mentioned this form. It's pretty universally not liked in the state, both by the clinicians who are asked to complete it, as well as, from my understanding, most of the judges who rely on it then to make determinations of guardianship. And in California, we refer to it as conservatorship, both the person and the estate. But we're a bit outliers there. And so we usually, speaking across the nation, we try to refer to it as guardianship. Some of the areas where it is lacking is that it really does not have a great deal of information on the form that allows the evaluator to directly report on functional abilities of the individual. So things that I think Dr. Drogan and Dr. Karlowicz talked about earlier in the seminar about activities of daily living, instrumental ones and basic ones. And those are so critical that information, as well as the information pertaining to the individual cognitive abilities, that there's a merging of those different areas or domains of information. It's critical. It also really lacks any, the current form lacks any way to really communicate culturally relevant information, like what values and preferences this individual had for their own life that might be driven by cultural or religious issues. And that's so important in determining what's going to be in that individual's best interest. Hopefully, the information that is provided to the judges supports their ability to weigh all of the evidence and then determine if this guardianship is in the individual's best interest. Given the status of the form in California, I almost universally attach a report that summarizes the parts that I think are not there, that the judge, I will hope, will integrate into that decision making before orders are written. So in this case, with this situation, if I had completed a capacity assessment that led to the guardianship initially, but now it's being heard again in a different court, perhaps in a civil case, or there's a criminal case unfolding, if I received a referral for a capacity assessment, the first thing I'm going to do, as Alison just mentioned, is I'm going to ask who's ever referring to me, the attorney, I assume, its capacity to do or decide what. What is the question that I can best help the attorney with, so that then they can proceed with the case, given evidence that I'm able to generate from either a current assessment, a past assessment, or medical records or other forms of records from the nursing home or wherever, that will help me to form an opinion about the capacity to do or decide whatever that was at the time that occurred. Can I form an opinion about that that's going to help in the process of the case?
Okay, so Dr. Olsen, let's fast forward or just move forward to the financial recovery case here. Let's say you've had no prior role in this case, but the public guardian now wants you to serve as an expert. How do you assess capacity, let's say 2 or 3 years later? What would you be able to testify to regarding Ms. W's capacity several years earlier?
And then again, I can say that there are times when I can offer a really solid opinion that will be helpful in the case, and there are times when there just is not enough information to really form a good opinion. And that's most unfortunate, because sometimes it really stymies the process. But where I can, I do. And basically, it's the information that we've talked about. I really want concrete information, such as reports from prior medical assessments, concrete examples of the individual's functional ability that may come from interviewing staff or providers in the facility where she was located, so that I can get a sense of what she was able to do or not do, either cognitively or physically. But in this case, it's more likely related to her ability to make decisions in terms of giving gifts. Was she aware of those kinds of things? And that you can't use a really good, as Laura Mosqueda says, a retrospectoscope. That's really hard to do, because you cannot pose those questions to the client 3 years later because of the progression of the disease. Whatever you hear or learn may not really apply. So you rely on those other forms and sources of information to arrive at opinion if you can. Sometimes it's doable and sometimes not.
Thank you. So Judge Holland, you are now hearing this financial recovery civil suit. Parties have not been able to come to any type of agreement. I'm going to ask you a series of questions, okay? I think I'll just ask them as a group and you just begin to answer because we're a little short on time. So what are you looking to hear with regard to the alleged financial exploitation? What type of clinical evidence would you look for? How would you go about weighing the evidence of Mrs. W's capacity that goes back 3, 4, 5 years? Would the evidence from the guardianship case be relevant to you? And I guess the final question would be, let's say there had been a criminal prosecution as well. Would evidence of a conviction be admissible in this civil case?
Those are great questions. The law is different in each state. So this is going to vary from state to state. In Oregon, in addition to how would this come to the court and be in trial? It could arrive in a couple of different ways. One is there are common law claims such as conversion. There's the undue influence to try and void a transfer. There are common law aspects. There's also a statutory claim, which is for a vulnerable person, and under Oregon definition, it includes any person who's 65 or older, who suffers damage by reason of, and in this case, it would be financial abuse, may bring an action against the alleged abuser. I would question not only about each of the individuals, but there would be a question of whether or not the facility is also should be a defendant. Have these people done this before? Is there a pattern of these employees that either should have been known by the facility or had happened when they worked elsewhere? Was this negligent hiring? Was this not doing due diligence with regard to it happening within their own facility, and yet they continue to have the person work there? And so there are aspects of this with regard to the facility as well as the individual abusers. Under this particular statute, which is Oregon Revised Statute 124.100 and other statutes there, in this type of case, if it's brought through this statutory, then if the plaintiff prevails, and this would be the guardian on behalf of the plaintiff, then the court's required to award the plaintiff an award equal to 3 times their damages. So if a jury makes a determination that a particular amount is what the damages are, then the award will be 3 times that amount, plus attorney fees, which are not generally recoverable in a civil common law action, plus the guardian fees for having to bring this action. So there's some weight behind prevailing in this type of case. And as well, if a defendant is convicted in a criminal proceeding of conduct that forms the basis for the lawsuit under this statute, whether it's because they pled guilty or were found guilty, then the defendant is stopped from denying the conduct for purposes of this action. Now, the action may continue and have to go to trial with regard to the amount of damages, but the conduct itself, the person would be stopped from denying it. So yes, the conviction would come in this type of case itself. It also has a longer statute of limitations than most common law actions, which is oftentimes 2 years from the date of discovery. This is, under this statute, a 7-year statute of limitation after discovery of the conduct. So this is in addition to any other civil remedy or a criminal remedy, which could also award restitution as part of a criminal conviction if there's in a sentencing. But it certainly has advantages, a lesser burden of proof than in a criminal case, but that may be very effective for a plaintiff. In terms of looking at what kinds of evidence I'm looking at, it depends when the guardianship was entered. You know, the relevant time is at the time of these alleged gifts or the transfers of property, which was several years before the guardianship took place. So is it relevant? It depends. What we're trying to get at is what was the capacity of the plaintiff at the time that this was occurring and the conduct was occurring. And as was said previously, I would echo a diagnosis of dementia is not particularly helpful at all. First of all, especially in the earlier stages at mild dementia, even medium dementia, there is fluidity between confusion and awareness and clarity that's very difficult to quantify. And so that part isn't helpful. What's more helpful, as was also discussed, is medical records, any other assessments, what was being done at the time of this. I'd also be interested to know whether or not she had a will, because she may have had her own estate plan. Just because she didn't have family, there may have been organizations that she wanted to contribute to that were helpful to her or meaningful to her. And to know that, as opposed to what ended up happening, which really left her without any means. So I'd want to know that also.
Great. Thank you. I want to thank all of you because you guys have handled these scenarios so incredibly well. You've provided so much wonderful information that I know that our symposium attendees are just going to find so valuable. I want to close by asking each of you just one final question because we are really so close to time. So the question is, what is one key thing you want our audience to take away from today's session? And so I'll start with you, Rima.
So decision-making capacity issues are complex. For instance, APS cannot rely solely on a case manager's assessment or solely on a psychiatric evaluation or rely only on what's relayed to us by referral source. We have to utilize various resources and tools and put these together like we're putting together a puzzle.
Great. Okay, Bonnie.
Thank you.
It's really an extension of what Rima just said, that the complexity requires that we integrate multiple sources of information, including the individual's values and preferences, their functional abilities, as well as their cognitive status, so that all of those things integrated then can help us understand better what their preserved as well as their impaired capabilities are.
Alison.
Well, I think that Bonnie and Rima just said exactly what I was going to say. So I'll use my 1 second just to do a shout out for two things. One is to please look at the recommendations of the National Guardianship Summit. And if you haven't, please look at the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, because those things will help us do exactly what we've been talking about, focusing on people's strengths as well as their challenges. Thanks.
Thank you. Charles, what's that one thing you would tell everyone? You're on mute.
Thank you. Actually, jumping on what Alison just said, the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, I had the privilege of serving as an observer on the drafting committee on that. And we looked at the states with the best guardianship laws and the states with the worst guardianship laws. And it's kind of scary. And states with weaker guardianship laws, that's a really good place to start for addressing that. And I also want to very quickly answer Judge Holland's question about a will. There were too many facts for it all to go into the fact pattern, but the answer is yes, Mrs. W had a will. She gave her entire estate to 3 very prominent charities.
Great, great, great. Okay, Judge Holland, what's that one thing that you would want this audience to take away from today's session?
Hopefully the audience takes away that we need to improve outcomes for older adults. And how do we do that? I think that a person's constitutional rights and due process rights should not depend on where they live. It should be wherever they live. This is not just about education. It's about changing the culture of our society as well. It's both changing the law and changing the practice, because both need to occur. Through this, I have been thinking about as well how else to do this. And I'm wondering if, because of all of the issues with regard to monitoring and the length of time and the loss of rights that people have, that maybe what we need to do for a period of time is to go to the legislature and amend these statutes to limit the length of time that a guardianship is entitled to be in place. We certainly do that for involuntary civil commitment statutes. There is a time limit, and maybe we need to do that for this as well, for this period of time. I'd appoint counsel for every respondent in a guardianship case. And I think the other aspect to get better outcomes is to collect relevant and meaningful data about who we serve, who we are underserving, and how we can better assist, be of assistance for those that we serve. Thanks.
Thank you. Thank you all. And now I'm going to try to turn to Naomi Karp. She's been monitoring your questions and your comments in the chat, and in the time remaining, Naomi, can you highlight maybe just a couple of the questions so that the panel could hear from our audience?
Yes, I will. Thank you, Edwin, and thanks to all the panelists. This has been fantastic. I just want to start by saying that I loved the anecdote from Charles about the Facebook posts with the jewelry, and that should be a cautionary tale for all of us about social media. But getting back to the topic at hand, Charles, a couple of questions for you about the last case, and you can answer this about the real case. One question was, are you able to get all of the medical records in under the business records exception, or do you have to subpoena the creator of each record? That's a very lawyerly question. And the second question is, were criminal charges brought successfully against those who should not have received hefty gifts?
Thank you for both those questions. So as for the first question, in Illinois, the guardian, assuming it's within the scope of the powers given to the guardian does not need a subpoena. We just ask for the medical, we can demand the medical records even without a subpoena. We step in for the powers that the court gives us. We step into the shoes of the individual. Just as you and everybody in the audience, it's your medical records. You can ask your doctor for your medical records. It's your right. assuming that's part of the authorities given to the guardian, we step into those shoes and we do not need a subpoena. The second question is the state's attorney filed criminal charges against 2 of the 5 exploiters. One was kind of the main ringleader and got most of the money, and a second one as well. It didn't just happen, though. We referred this case to the state's attorney after our investigation. We put everything together and tied it together with a nice red bow for them, and they were not interested in it for reasons we strongly disagreed with, and we sent a number of letters about why that decision was a mistake and about how full justice for Mrs. W required a civil recovery as well as criminal prosecutions. And by the way, that was something that Mrs. W told us that she wanted in this case. And the state's attorney still did not file any charges, so we held a press conference. And there were front page newspaper articles about this case and why no criminal charges. And shortly thereafter, they announced criminal charges against 2 of the perpetrators. And those 2 cases remain pending.
Okay, bravo for the press conference. Okay, I guess we could take one more question. This is for Rima. So, and this really is probably mainly in response to the second case about the will contest. There were some questions about the role of APS after the person is deceased. Does APS respond to a complaint if the exploited person is now deceased?
Let me unmute myself. In New York, we do not. If the person, if the victim is deceased, we will not follow through with an investigation.
Does anyone else have any comment on that, or anything else one could do after the person is deceased? Okay. Well, great. I think we're kind of out of time. And I have to say, I think people were just so rapt listening to this panel that we didn't have as many questions as we had the other 2 days. But it's not for lack of interest. There's still a lot going on in the chat. This is stimulating a lot of conversation, and this was really fabulous. So thank you so much.
Okay, well, this is Andy. I'm not up yet, but I'm sort of looming in the background. I wanted to thank Edwin and this panel. It really was phenomenal. You exceeded our expectations in terms of covering so much ground. And so again, thank you for your time. Thank you for your thoughtfulness and for all you do to help older adults around the country. So thank you for that. With the last few minutes, first thing of all, I just want to thank all the panelists and the conference organizers. As you can imagine, it takes a tremendous amount of people to put something like this together, and thought and care. And anyway, just want to thank everyone. I also wanted to thank the participants. I'm not sure the participants can see just how many people participated, but at its height, there were over 1,200 participants during one of the days, and still hundreds today. And I think it shows the commitment of all the participants to this issue and the advocacy out there, as well as the real hunger for additional information and training. I will say that I have learned just as much from the chat room discussions as I have from the panelists. And so again, without you here, this would have been a very different symposium. And so I appreciate everyone taking the time to participate. The second thing I just want to say quickly was the fact that, again, after the symposium, everyone's going to get an evaluation. Please take the time to share your thoughts, both the good and the bad. We tried our best. We tried to make a number of points, but there are obviously a number of things we could have done differently. And we want the benefit of your input as we plan future events. So please take the time and share your views on that. The last and the heaviest lift was trying to encapsulate the last 3 days, which in hindsight is just a ridiculous task. I think the last panel did an excellent job in talking about when they were wrapping up about a lot of the main themes that came out of the conference. So I thought instead of trying to encapsulate, I would just talk a little bit about the goals which our team and some of the organizers had going in to this symposium. And I think that's been borne out and highlighted what else we have to do. The first was simply, as one of the last panelists said, is just to show the complexity of capacity assessments. There is so much misinformation and misunderstanding out there about what these things are, what they can do. There are misassumptions in terms of the aging brain and the fact that all older adults may have cognitive impairments, which isn't true. And even if there is a diagnosis, which has been echoed throughout the entire symposium, that is not destiny. It does not define or answer the question about whether or not someone has a capacity, much less a capacity to do something, to do what, which Charlie talked about the first day. And that is a theme I think that we've tried to echo throughout, and I think we did. I think we also, coming into this symposium, wanted to just highlight how many different ways capacity comes up in both civil and criminal proceedings, and the profound impact that these assessments or non-assessments have in how older adults are treated, and the experiences that they have in both the criminal and civil justice systems. And that lack of general awareness is dangerous. The fact that the general public is not aware of all the different places it plays a role really has a profound impact on all of us, not just older adults. And so we hope that this symposium took at least one step towards raising that awareness. I think the last thing I would just note is that there is still a tremendous amount of work to be done. The Associate Attorney General talked about how this is just the first step, or one step in the conversation, and that can't be any truer. I think, if anything, the chat room discussions, yesterday's participant discussion, just shows how much work we have to do to raise awareness, do more training in terms of highlighting the role that capacity plays in all these different proceedings. Potential legislative fixes have also been mentioned, policy fixes, training opportunities have all been highlighted during this conference. And we and our team have really tried to write all of those down, but there's more to be done. And so we invite all of you, either in your comments on the evaluation or just to email us directly with your thoughts. We're going to spend several weeks, if not months, trying to really delve into what happened over the past 3 days and all the information that we've gathered. We will try to put as much of everyone's thoughts, make this available on the Elder Justice website, but I think it's going to help inform efforts, but not just at the Department of Justice, but hopefully with the Elder Justice Coordinating Council and other federal agencies on all the things that we can do better on behalf of older adults. So with that, I thank you all for your time and your attention over the past 3 days. Thank you for all of what you do on behalf of older adults across the country every single day. And have a great rest of the day. Thank you so much. Take care. Goodbye.